The Online Harms Act has created quite a stir, but we are starting to get some clarification. Government officials say online hate speech would have to portray a group as inherently violent or unhuman to meet the threshold to be probed by a human rights tribunal under the newly proposed law. Justice officials briefed reporters on the criminal code provisions in the government's bill to tackle online harms, and those changes have come under harsh criticism from civil liberty groups and legal experts who are voicing concerns about the potential chill to free speech. Joining us now to discuss the Online Harms Act is Joanna Barron, Executive Director at the Canadian Constitution Foundation. Joanna, thank you very much for joining us on Forum Daily.
Thanks for having me.
The CCF has stated that the Online Harms Act poses a threat to constitutionally protected expression. Can you walk us through your viewpoint on this?
Yeah, so there's a few things. First of all, the bill creates a new crime for any offense motivated by hate that's now punishable for a term of life imprisonment. It also criminalizes what's called advocating genocide, also by life imprisonment. Both these are terrible things, but the line between merely repugnant speech, offensive speech, and actual hate speech has always been very difficult to draw. But the bill goes even further, and it brings back a civil remedy for offensive, harmful, or hateful speech. This was previously Section 13 of the Canadian Human Rights Act, and that would allow any member of the public to make a complaint about any person for disseminating hate speech online to the tune of fines of up to $70. And this would not be investigated on the more stringent criminal standard of proof beyond a reasonable doubt, but instead be investigated on a balance of probabilities. And then one last thing that I want to mention, which is just so shocking, is that the bill also effectively criminalizes pre-crime. So it allows any person to apply for a prophylactic peace bond against someone that they suggest may commit hate speech crimes in the future. And you could be in prison for a year, or you'd have to submit to an ankle bracelet and ongoing monitoring before you've even done anything.
You mentioned the burden of proof between the civil side and the criminal side. How much lower is the bar on the civil side?
Well, so the proof beyond a reasonable doubt means that there is no reasonable question in your head that this act occurred. That's the burden that the state has to prove in order for the state to take you into its custody and prison, of course. Balance of probabilities is just, it's more likely than not. So it's essentially, I like to think of it as 50-50 as opposed to proof beyond a reasonable doubt to me is like 95% plus. So it's quite a bit less stringent.
And you mentioned proactively notifying enforcement about an individual. It almost seems like a red flag law, but for hate speech, how exactly would that be carried out? Is there any burden of proof in that process to ensure that it's not weaponized to, let's say, stifle those you disagree with?
Well, the government has suggested that this would have to be approved by a judge as well as the attorney general, and that unlike the civil remedies, it would be subject to the more stringent criminal burden of proof. Nonetheless, I think it's inherently an overreach to punish someone for acts that have not yet elapsed. And there's no, suggestion that you have to have a track record of committing hate speech, but just the inherent idea that we're going to submit you to imprisonment for something that you haven't yet done is an extraordinary concept.
And the Act also puts a lot of requirements on social media platforms. Can you explain to us what those new rules are?
Yeah, so social media platforms now have to flag and identify and take down hateful content if they don't. So each platform has to come up with its own plan for combating harmful content on its platform, which of course falls short of hate speech. And if their plan or their method doesn't satisfy the government, they could be on the hook for fines of up to 6% in global revenue or $10 million. So I think we can also assume that platforms will very much err on the side of caution, rather be on the hook for these very hefty fines. And the last thing that I want to just mention with these advocating genocide, life imprisonment terms, is that the actual crime of assaulting a minor, sexual assault of a minor, is punishable by a term of up to 14 years. So now we have speech crime being punishable by higher terms of imprisonment than actual physical assaults.
Joanna, thank you very much for your time today.
Thank you for having me.